little bit about Special Education Legal Fund before we begin, especially for those of you who aren't familiar with us. Special Education Legal Fund, or SELF, was founded in 2018 to provide grants for families in need with children in the special education system. Since our founding, we have provided over $300,000 in grants for legal support from qualified special education attorneys to 75 families in 30 school districts in Connecticut and Westchester County. As far as grants are concerned, Special Education Legal Fund provides grants for legal support, as I said. For more information about grants or how to begin the application process, please send me an email at christine@spedlegalfund.org. I will put my email, it's up on screen right now, but I will put it in the chat later for anyone who is interested in learning more about SELF. Families are eligible for this program if they have adjusted gross income of below 300% of the federal minimum poverty line, which is $76,400 in Connecticut. They have a child with a current IEP, and they live in Connecticut or Westchester County. We are currently accepting applications from families in all school districts in Connecticut and Westchester County. We are super excited actually tonight to present our 2021 webinar schedule for the rest of the year. Obviously tonight is Understanding Outplacement. Our next webinar will be in February, which I'll discuss on the next slide. March, we will focus on special education advocacy. In April, will be post-secondary transition programs. May is the summer slide, extended school year and beyond. And finally, we're gonna wrap up our webinar series in June with the year in review. For more information about these panels, please follow us on Facebook or Instagram at @SpedLegalFund. The webinars are free and open to all, and you will register for it on Eventbrite just like you did for this one. Next month's webinar on February 9th at 7 o'clock is on the topic of residential special education schools. It will feature representatives from Chapel Haven, from Glen Holmes School, from Shrub Oak International School, as well as special education attorney Lawrence Berliner, and it will be moderated by me. And now it gives me great pleasure to introduce the distinguished members of our panel tonight. First up, Andy Feinstein, is it Feinstein or Feinstein? I'm sorry, I didn't even ask. Is well known to all of you if, it's too late now, if you are familiar with SEEK, Special Education Equity for Kids, and their informative panel discussions covering special education issues. Andy has over 25 years of experience practicing special education law on behalf of parents and families, and he is deeply involved in the special education community in Connecticut and beyond through his work for SEEK, as well as for COPA, the Council of Parent Attorneys and Advocates. And Andy is an all-around great guy who's been an invaluable supporter of SELF since we were founded. So thanks for joining us, Andy. The next member of our panel is Terry Bedard. Terry is a special education attorney who brings to the field of special education law a unique and invaluable perspective as a parent of a child with special education needs. Terry has practiced special education law for many years in Connecticut on behalf of parents, is deeply involved in the special education community through her involvement with SEEK and with the hearing impaired community in Connecticut as well. And also for those of you who know him, Terry also cut her teeth in SPED law under the tutelage of Howard Klebanoff. Terry's been a longtime friend of SELF, and we are really pleased to have her support over the last few years. So welcome, Terry. And finally, the last member of our esteemed panel is Paul Barger. Paul is a partner at Barger & Gaines in Westchester, New York, and he practices special education law on behalf of families in New York, Connecticut, New Jersey, and Michigan. Because of the breadth of his experience, Paul brings a unique perspective to this panel on the topic of special education with a multi-state focus. We are very excited to have Paul on this panel, and my family in particular was fortunate to have had Paul's advice on a matter just last year when the independent school that my son was attending closed unexpectedly in the middle of the year. So thank you, Paul, for joining us. And my last introduction for the evening is going to be for our moderator, Lara Damashek. Lara is a board member of SELF, and she's a wonderful friend of mine. If you tuned into our last panel in November, you were able to see Lara as the moderator of that as well. She is a special education advocate in Connecticut, who previously was a special education attorney in New York City with the law offices of Regina Schuyler. And her experience in that way, as well as a public school teacher and a parent who has navigated the special education system for her own child, gives her a unique and compassionate perspective for families and parents. I'm so excited for her to be moderating this session. So I'm going to remain on the webinar doing back-end stuff. If you, anyone who's on the webinar has questions for the panelists and you would like them posed to the panelists, please email them to me at christine@spedlegalfund.org. And again, I will put that in the chat in just a minute. Finally, before we actually begin, nothing would be complete without a disclaimer. This webinar panel is presented for informational purposes only. This webinar is intended as a resource for families who are navigating the special education system in Connecticut or New York, and is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating attorneys in the panel. For webinar participants, this panel should be viewed as a public forum. Please do not ask questions via the Zoom platform, either in the Q&A or the chat, about your child or your child's legal or educational situation in this forum. As I said before, please email questions to me at christine@spedlegalfund.org. In your question, please refrain from any comments that include identifiable information about your child, including name, grade, school, or school district. Please remember that your screen name may be visible to the participants in this panel, as well as to the panelists and Special Education Legal Fund. Finally, this webinar is being recorded and may be distributed or shown at a later date at the discretion of Special Education Legal Fund. So here we are. What is outplacement? I'll ask the first question.
To the panel.
Andy,
You want us to just jump in?
Just jump right in. We'll start with what is outplacement?
What is outplacement?
Well, we were talking about this a few moments ago, and you know, outplacement is a placement at a school other than the school to which your child would normally be assigned. There are outplacements to private schools. There are outplacements to public schools, charter schools, magnet schools, regional educational service centers, BOCES in New York. And what I think is really important is that there are, fundamentally, they come in three different flavors. Flavor one is under an IEP written by the school district, which is, means that the district's goals and objectives, the district's responsible for the quality of the program, the district's responsible for all costs associated with it. That's one. Number two is what's known as a parental placement. Parents say, I want to send my kid to private school, and they do that. If it's a child with a disability, the district in which the private school is located has certain financial obligations to the private school, called an equitable share, but that's not resources that's in any way accessible to the student themselves. And there's no requirement of following an IEP. And then the third flavor, which is the flavor I think that's most interesting to most of the audience, is the unilateral parental placement, where the parent determines that the program offered by the district will not provide their child with a free appropriate public education, places the child privately, and then needs to demonstrate that the program is inappropriate and that the placement is appropriate and that they played fair, that it was equitable. And in those circumstances, the parents can be entitled to reimbursement. If it goes through the hearing process, it would be full reimbursement. And if it's, but in most cases, it's negotiated as a cost sharing arrangement. We'll talk further about all of those, I assume, but it's important to keep in mind that outplacement itself covers a broad range and that there are those three basic varieties of it.
Okay, thank you. So when, I'll start this question, I'll direct this first question at Terry. based on your experience helping clients pursue outplacement, when do you find that it's appropriate for a parent to seek outplacement, or when is outplacement typically sought? And can you explain that process for us?
Yeah, absolutely. It's interesting that we're talking about outplacements this evening, because this was the first needle I learned to thread as a young attorney and mother over 20 years ago. Our son was born with a hearing loss, as Christine mentioned before, and we didn't discover that right away. So he had some very significant language and communication delays, and we felt he needed an outplacement at a special school for children with hearing loss in order to build those foundational skills of communication skills, really, that he needed while he was young. He was only 3 years old and his brain was so plastic. So my husband and I walked into our very first PPT meeting feeling extremely outnumbered by the number of district representatives who insisted that they had a great program for our son. We listened, we asked questions, and we requested a visit to the program. After seeing it, that's when I got busy building our case for why the district program was not appropriate to meet our son's educational needs and why the outplacement was appropriate. So he was outplaced for 3 years, and then he was mainstreamed with supplemental aids and services here in Glastonbury from 1st to 12th grade. So in our case, when we started this process, we had no experience with the school district. Our son hadn't been in the program previously. So in some ways, it was harder because we couldn't show how the current program that our child was in was not appropriate. And so, we had to look at the program itself. And so you start with your child's educational needs. That's really the starting point. That's what we did. And that's really what I think is a good starting point for parents. And how do you know? How do you know when you need an outplacement is the question. So we knew because our son needed more intensive language and communication. He needed good speech and language role models, speech models. He needed teachers that were qualified and experienced and trained in that particular area. So those are some of the things that you can look at. I think my more practical advice for parents, generally speaking, if your child is already in a program and you're not happy with the program, look at the data that supports a lack of progress. There could be, for example, some regression that you're noticing, maybe your child is backsliding in their grades. You're seeing the same goals and objectives year after year. And then the progress reports are not really showing progress. They're showing limited progress or unsatisfactory progress, or you're seeing that there's not a great deal of mastery of goals. And so I think those are some of the things that you start with in terms of looking at when you need an outplacement. And I have some advice in terms of how you go about asking for that outplacement. I don't know if you want me to get into that at all, but
yeah, well, so it sounds like your outplacement was more of that unilateral, where you decided to place your student. And then did you seek reimbursement?
Actually, it was a publicly placed outplacement. Yes. So we convinced our school district that they could not provide an appropriate program and that this outplacement was appropriate. And it was done through the PPT process. And so that was the first category or classification that Andy was talking about earlier, when the public school says, yes, we agree with you. We can't provide an appropriate program, so we're going to place publicly. So that's the kind of placement it was.
Okay, got it. And Andy, you mentioned earlier that some families will choose to place their child privately and then seek reimbursement after the placement's made. In your experience, what are the advantages and disadvantages of going that route versus what Terry has explained?
Well, I mean, what parents are generally looking for is a specialized program, often For example, people might be looking for a program that actually has a staff of Orton Gillingham trained instructors. That's generally not available in public schools. It's available in some special ed schools. I find the following two things to be the most frequent reasons that people seek unilateral placement. One is that their child cannot tolerate the bustling nature, the number of people, the size of a public school. And public schools generally take the position, oh, we can provide an appropriate program and we'll have a special room for your kid, so he won't be subject to all this. Well, that doesn't really work. So that's one enormous reason that people outplace. And the second reason is the sort of specialized instruction that might be available. The advantages of the IEP placement, of course, is that the district pays for everything, and the district's responsible. And so in virtually every case, I would argue that parents at first ought to seek the placement through the IEP team, or as we call it in Connecticut, a PPT. But public schools are generally restricted from placing a child in a non-approved school.
But that brings up the distinction between non-approved schools and approved schools. And so can you, Andy, just speak a little bit about in Connecticut, the APSEP or the approved school and versus independent schools. And in New York, we also know there are New York State approved schools. Can you tell us a little bit, just in general, what are the main differences that parents should know?
Well, in order to be an approved private special ed placement, there's of course this whole process you got to go through, and they've got to check the number of fire escapes and the like. But you're also committed to following the Common Core structure, to giving the standardized tests that are given, to basically following the educational program that the State Department of Education lays out. There are a number of schools that say that's just not appropriate. We're not meeting the needs of our kids if we do that. And so there are schools that have decided we don't want to be an approved school. Now, the fact is that the district probably cannot place at those schools. There's some exceptions to that, but as a general rule, they can't place at those schools. And if parent is seeking reimbursement for one of those schools, the district looks more askance at a non-approved school.
Right.
The other side of that, and I got to say this is the most, this is critically important. In order to be an approved private education school in Connecticut, you've got to be a self-contained special ed school. Now, often what you need is a program that has typical kids as well. And there just are not approved private special ed placements with typical kids. And that's an enormous problem. And frankly, one I think that conflicts with the federal law, but nobody's brought that case yet.
So you mean there's a shortage, or there doesn't exist, there is an absence of inclusion private schools that are approved. So
exactly,
right.
approved schools that are inclusive.
And in your experience, parents are able to sometimes seek reimbursement for private schools that follow that inclusion model?
That's right. There are, unilateral placements. We do succeed in working out agreements generally. And I got to say that 99% of unilateral placement cases are resolved through settlement agreements that involve cost sharing. We work out a whole lot of them that are two schools that are not on the approved list.
Okay. And is there, this may be obvious to some of us, but what is the advantage of the financial advantage of pursuing an approved school? I mean, if you obviously, for some families, these private school tuitions are completely daunting, and it's a lot of money to shell out and pay and sue for reimbursement. So, I mean, I know that when I was practicing, we would sometimes encourage families to pursue an approved school first, because there was the potential for the district to fund that directly.
Well, there's obviously that. It could be an IEP placement. But even beyond that, I think as a general rule, parents do better on cost sharing if it's an approved school than it's a non-approved school, on general terms. But I can't prove that. Each case is individual, and there are cases where the district pays 100% for unilateral placement, and there are cases where the district pays 30% for unilateral placement, and that's based, not on, it's in part on the school, but it's much more.
Right.
Well, let me say it this way: how much a district pays in cost sharing is, in my mind, entirely a product of how likely they think they are to lose a hearing on it.
Right.
And if it's a non-approved school, our ability to win a hearing on it is substantially reduced.
Okay, thank you. Paul, we haven't forgotten about you. We were waiting for a question where we could draw on your experience working in so many different states and having such a various client base. When I think outplacement is probably a very popular topic in your practice. When families come to you to learn about outplacement or with outplacement questions, what do you find are some misunderstandings they have? What is their understanding of what outplacement is? And if you can just speak to that and how you help inform the parents from there about outplacement.
So especially in New York, I think the biggest misconception that people come in with, which is not their fault, it's not something that people would just readily know, and it's along the lines of something that Andy was just talking about. But the biggest misconception is that a family will be interested in a private school, and it's not on the state approved list. And they are generally surprised when I tell them that the public school district cannot place in New York. It's a hard and fast rule. There's really no exception, but that they cannot place in a non-approved school. So that is one thing that when the first time we're meeting with a family, they're very surprised to learn that. And I would even say down the line, it can be very confusing because they will want the school maybe clearly meets the child's needs. The state approved options don't, and yet the district can't do anything with that. The district's options are very limited in where they can place because of the state approved list, and the non-approved list can be much more robust. It could be give many more options, and so it becomes very confusing as to why that is the case. I think both board attorneys and attorneys for families share this one position on this, that it's very limiting in that way. So I think that is something that is often causes confusion. I think the other thing is this. There is an importance in recognizing that the district, in their opinion, the people that work for the district, that they're especially at a hearing level, they're considered experts. And so a family, when they'll come to us and they'll ask, they'll say the program's not appropriate, we have to explain to them that the district may disagree with them, and in fact often does disagree with them. We end up in unilateral placement cases for that reason. So it's not as simple as just the family having an opinion, having what they've seen, even having their own expert. You need to recognize that there can be a reasonable disagreement between the parties.
Okay, thank you. And is there something that you find the parents are most surprised about when you're working on them in an outplacement case?
I think that especially in a unilateral placement case, that one of the three that Andy mentioned earlier, I think the most surprising to families, this doesn't really happen in New York City as much, but certainly in the suburbs it does, that the family is committing financially to the private school. It's their contract with the private school. They're putting out that money, and that they're then seeking reimbursement from the district. And along those same lines, the amount of time it takes to either get to a settlement or through a hearing can be very, very lengthy.
Right. So we're not going to quote you to any of this, but so if a parent comes to you and says, I have the perfect private school for my child, but I want to, sue the district to pay for it, what is kind of like the general overview that you give them? How long does that take? Is it, a year? Is it 3 years? And can there be a settlement for 1 year, 3 years? And
So as far as the length of time from the moment they would come to us depends upon where they are in the school year. So if, for example, a family were to come to us now, January, and they're looking at a placement for September, that process is going to take a little bit longer because we need to go through the annual review meeting. We need to have the presumably a neuropsychological evaluation done. There are notice requirements. There are all these different things. And we wouldn't necessarily be pursuing even a settlement, but definitely not a hearing until the next school year. So the timeline is very, very much extended at that point. If a family comes to us in the middle of the year to make a placement, that would generally, more often than not, that's for a residential program because those placements happen throughout the year. That can be, I guess I would say could be a shorter timeline. I will say that from beginning to end, it can be a year. It can be, and that's before appeals. The process can be very slow. I know we're talking about Connecticut and New York. I'll just add that New Jersey, where we also practice, is way longer. New Jersey takes longer than both Connecticut and New York. I think you asked how long can a settlement be? So I love multi-year agreements. I think that there is just incredible value in a family knowing long-term what their financial responsibility is. And so we try very hard when it's possible to have multi-year agreements, 2, 3, sometimes 4. That gets a little long, but hopefully 3-year agreements, because then the family, they know they're locked in. They know what they're paying for the private school. They know what money they're getting contributed by the district, what their cost sharing arrangement is with the district. They don't have to worry about spending money on me during that time period. They don't have to worry about getting another evaluation during that time period. So there's real value in that for the family.
Thank you.
I would add to that there are families that are absolutely 100% convinced that they have found the perfect placement. They want a multi-year deal and they want to lock it in for 2, 3, 4 years. And then they'll come back after a year and say, we're really not happy with this placement and we want to go back to district. I've had that happen in a percentage of my cases. So we just want to make sure that that settlement agreement allows for that option and it doesn't lock the parents out from actually finding another placement or coming back to district, which usually isn't a big deal, but you just want to make sure that the contract is consistent and allowing that out if need be.
And I would also just, if I could, Terry, I completely agree. I think it's a great point. And then I think it's important not only to make sure that it's in there in the settlement agreement that they can return to district, which I agree is not usually an issue if a family wants to do that, but potentially that if there needs to be a transition to a different private school program, either that the agreement is void and the family retains their rights, or that there's a possibility of transferring to this program and having the contribution, the cost sharing apply towards that other program. So because otherwise you end up in a situation where a family can continue a student in a placement that's not working because of the financial implications of that. So yeah, I would, I think very, very.
I want to bring up another issue on time. Look, our fundamental goal as lawyers, when somebody comes to us, is to demonstrate that the program offered by the district is not appropriate. That is, under the law, inherently in the province of an expert. One needs an expert who is going to say this program's not appropriate. Now, it's an enormous problem right now with COVID that we can't have observations because observations are often the most telling way to demonstrate that a program is inappropriate. The other 2 ways is to show a total lack of progress in the district's data, or to have an evaluator do probably a neuropsych and be able to say that this is what the student needs and that the program is not providing that. So for most clients who come to me saying, I'm not liking, any town schools, and I want to place my kid at the Gold $sign Academy. I have to tell them that they need to get the expert who's going to say that the Anytown program is not appropriate. And that, right now lining up neuropsychs can be 6 months out. And again, observations, which are really critical, are probably unavailable. And so that's what creates a time lag for me.
Mhm.
I mean, once I have the expert report, I can file, we get to mediation very quickly. Most half cases settle on the day of mediation. And, at that point we can turn it around in 45 days. But I need the expert report. I need the evidence in order to make the case.
Right.
I've got a question actually from the audience. What happens if the school wants to outplace the child and the parent disagrees?
Okay, that is a big one. The district has to propose an appropriate program. The district can propose that we're going to send your child to, Edelbrook in Connecticut, for example, which is, a sort of juvenile court placement generally. And so a parent says, hell no, I'm not sending my kid to Edelbrook. That's usually a negotiated process where we find another school that's appropriate. You can end up in a situation, however, where the district where you go to hearing and the district says this is an appropriate program and is able to demonstrate that. The parents need at that point to be able to demonstrate that the program proposed is not appropriate. And that can be a real trick with some of these lower quality private schools.
I think a concept that everybody has heard about is called least restrictive environment. It's a basic tenet of IDEA, the Individuals with Disabilities Education Act. And just to touch a little bit on the history, I mean, before Congress passed IDEA, back in 1975, if you were a child with a disability, you were automatically placed in a special school or a self-contained classroom. And so this segregation really prevented children with disabilities from being educated alongside their non-disabled peers in the regular education classroom. So the key provision I was just referring to that everybody has heard about, least restrictive environment, says that each public agency must ensure, and this is the key language, to the maximum extent appropriate, children with disabilities are educated with children who are non-disabled, and that they're removed to special classes or separate schooling or another placement, removed from the regular classroom only if the nature and severity of the disability is such that the education in the regular environment with supplementary aids and services cannot be achieved satisfactorily. So there is a presumption here that the child with a disability should be educated alongside their non-disabled peers. And so we were talking about the neighborhood school. That's really where the child should be educated. So when a district outplaces from the regular education environment, there has to be a good reason that the child is not being educated satisfactorily in the regular education classroom with supplementary aids and services.
Nice description. Good job, Terry.
Thank you, Andy.
And can you all speak a little bit, and you're all welcome to chime in on this, to the relationship between the IEP team and the outplacement? So once you've outplaced your child, how does the IEP work?
Well, a unilateral placement, generally, the parent is taking full responsibility for the program. The private school has no obligation to implement the IEP. Generally, I would suggest that they actually have goals and objectives and specified services so that when we're going back to extend the agreement, we can say, see, this is a truly appropriate program. If the child is placed out of district by the district through an IEP, then they write an IEP for the child in that program, and the private school is obliged to implement it. Now, we do have something of a difference in this regard between New York and Connecticut, but I don't know what's worth going into. but the basic point is that the private school, if it's an IEP placement, needs to implement the IEP. That's the basic rule.
Paul, did you want to
I'm
add?
going to chime in here. You know, I'm not an attorney, but I have a little experience in special education schools that are independent, and some independent special education schools will have their form of an IEP with goals and objectives. They might not look exactly the way the traditional IEP that you receive from your school district looks, but they will have, you know, a form of goals and objectives. Some schools don't have them. You know, some schools don't have a written list of goals and objectives. They don't have measurable, measurable goals. And these are things that, you know, for a parent that's looking for an appropriate placement for their child, these are really good questions to ask when you're looking at the gamut of schools that might be appropriate for your child. You know, how are these goals going to be measured over time, and what are they going to look like, and how do they sort of jibe with the IEP, or do they?
There's also that instance where there's a parentally placed private school. This is the case Andy was talking about earlier, where the parent doesn't have an issue with FAPE or the program that their district is offering. It's simply that they choose to place their child in a private school. This could be a parochial school or other school. So in that case, there's a service plan as opposed to an IEP. And it resembles an IEP, but it's not called that. But that's a case where the IEP doesn't apply, but there is a service plan. And I'm sure that people have heard about service plans and wonder, well, when does that happen? It's really when the parent places the child into the private school when there's no issue of FAPE.
Right. So I can speak a little bit to that, because it gets to be very confusing for parents. I know, what is the difference between an IEP and an IESP? I think one of the easiest ways to understand it is just like you said, if you privately place your child, it could be a parochial school, a general private school, and you're not suing for reimbursements. But you need services, like maybe you need speech therapy or OT. You are entitled to pursue those services through the district where the private school is located. So, right. So there's a little bit of, more language.
But notice,
that's exactly right. And yeah, I'm sorry.
Entitled to anything particularly from that district. The district has to fund an equitable share to that private school, which is based on the federal contribution divided by the number of kids in that school. So it works out to be $600-700 usually. And so if the school has 10 kids who have disabilities, they may get $8,000 worth of services, which could be, 1/5 of the time of a speech and language pathologist. It's nothing. As an individual, you have no rights to anything under a service plan.
You have no right to sue for FAPE either. You can sue the LEA, the local education agency where the private school is located, for a violation of child find, because they do have the obligation to locate, identify, and evaluate the children with disabilities within their LEA. So I think that's important to note, but you don't have the right to sue for a lack or violation of FAPE.
So I have a question. I don't know. I'm assuming there are some people in the audience who are from New York City. And a lot of people know that, for example, in New York City, there are many people who sue for reimbursement because there simply aren't enough programs in the public school to provide for students. When I moved out of the city and learned about the special education world in the suburbs, I was struck by the difference and how it was much more difficult to sue some of these school districts. Paul, I know you work with a lot of the highly reputable Westchester public school districts, for example. Can you tell us about, how hard is it to pursue outplacement in some of these schools that really do, bend over backwards to work with your child?
Yeah, it's a different world in the city and the suburbs. So like just comparing, comparing the city to Westchester is a really good way to look at it. The Westchester districts are, they provide a lot of services. Nobody should quote me on that, but they are certainly doing more and paying more attention than what's happening in the city. So in order to build a case, there are a number of factors that need to go into it. The first one is something that Andy said, which there's nothing I could agree with more than this, which is you need an expert. You need generally speaking, it's through a neuropsychological evaluation. It could be something else, but it generally speaking is a neuropsychological evaluation. The expert is the essential piece of this without any question. If a family comes to us and they lay out their case and they tell us how the district's program isn't working, the first thing we ask is, have you gotten a private evaluation? And we explain to them within probably 10 minutes, we need a private evaluation. It may not be today, but it's strategically when we would do it. There needs to be, the family needs to, the easiest way to lose a case for a family or to not get a settlement is to not cooperate with the district. So that means attending meetings, advising the district of things that are going on, consenting to evaluations, not unreasonably delaying evaluations, participating in the IEP team meeting, and if there is disagreement with the district, letting the district know, even informally, of that disagreement. One of the things that we've run into, even in some recent hearings, is that the district will take the position, yeah, the family placed out of district, the family moved forward with the unilateral placement. We got this report at the end of the summer, but at the IEP team meeting in June, the family never mentioned that they were concerned about the program. So it's important to document, have a document trail. Email is obviously the easiest way. Laying out the concerns, showing cooperation, getting the expert report, and building that case so that you can really make the arguments that you need to make. Because the thing to keep in mind here is that the standard is not what's best or even better for a student, and it's not to maximize a student's potential. Maybe that's what it should be. Maybe that's what we want it to be. But the reality is that a public school district's obligations to provide appropriate, reasonably calculated to provide meaningful educational benefit. It's not that high of a standard. And excellent suburban districts can do things to meet that standard. So it's very, very difficult. It's more difficult than it is to bring a due process in the suburbs than it is in the city. But there's ways to do it. And again, I go back to what I said at the start of this. The expert. You need an expert to say that the district's program is not appropriate, and you need that expert to say that the type of program where the family is unilaterally placing is appropriate.
I want to add two things to that. First, I'm not sure I agree with you, Lara, that the main reason for all those hearings in the city is because of the lack of programs. The main reason is because the New York City Board of Education does not have authority to negotiate agreements. In Connecticut, when I have one of these situations, I call the lawyer for the district and say, let's make a deal. And in a lot of cases, we make a deal long before any hearings filed. That's not available in New York City. And that was a decision made years ago by the Board of Education, which there's been lots of controversy about, and it's just a terrible policy. It's one of the many terrible features of the New York City Board of Education. And I got to tell you, having argued a half dozen or more New York City cases before the Second Circuit Court of Appeals is as disgusted with the New York City Board of Education as anybody on earth is. That's the first point. The second point, just to elaborate on what Paul said, there's a doctrine that the courts have adopted called the snapshot rule, which is the question of whether an IEP is appropriate is determined by what was in front of the IEP team on the day they proposed the program. And so if you get a lousy program at the time and then get an expert report after that, that's not going to help you. That may not even be admissible. You may have to go back to another IEP team meeting in order to bring that report. And then, if the districts are all smart, they'll say, yeah, we can implement this recommendation and this recommendation, and thereby undercut any argument that it's a failed program. And I suppose the third point I want to make here, just to amplify what Paul said, it is not a comparative analysis. The question is, first and foremost, is the district program appropriate? And only if we demonstrate that it's not appropriate, do we then get to produce evidence about the appropriateness of the private placement. And what that also means, in conjunction with the snapshot rule, is, we have lots of cases where the kids made almost no progress in the public school, and the next year in the private school is making spectacular promise. That evidence of the spectacular promise is probably not admissible. It's certainly not admissible for purposes of showing the district program inappropriate. We have other ways of getting it in, but it's not admissible for that purpose. And so that's really important to keep in mind, and something that I think I have to educate every client about. Never use the word better.
Yeah.
Or best.
Better and best. I constantly.
Absolutely remove that from your vocabulary.
Or maximize.
Or
Max-
maximize my child's potential. No.
I've got a question, actually. Is there a time frame that you have to allow for services in the public school before you can seek outplacement?
Let me try that in two ways. One, Supreme Court has said you don't have to stick your kid in the public school first before you can seek an out-of-district placement. That's
Yes, in theory.
That's
in
one.
theory.
And two, you have 2 years from the date of the alleged violation in order to bring your action. So the IEP team meeting June of 2000, placement in August of 2000. You have until June of 2022 to bring your action. And sometimes we do wait a while to do that. Waiting 2 years, I think, is really risky, but sometimes it takes 6 months, a year to get together all the evidence. But again, at that point, your kid is unilaterally placed. You have no chance to observe the district program. You have nothing. All you have is the paper of the district program. And so, and then the question is, was the program reasonable based on the information in front of the IEP team at the time they offered the IEP?
I think it depends on the case. You could have a case where a student is being bullied, for example, or is really having a difficult time accessing his or her education. And you don't want to wait too long in that case. It could actually be harmful emotionally for your child. So it's great if you have the funds to be able to unilaterally place and take that financial risk, but a lot of families don't. And so it's really important, I think, to develop that evidence and really know. I talked earlier about the data and really trying to work with your district in terms of, are there some additional supplemental aids and services that could really help in the placement? Is there another way that we can look at this? And could there be some, there are a lot of variations on that continuum of placements. Can we try something else and see if that works? But I think in terms of how long to keep your child, it really depends on how your child is progressing or not progressing.
And you mentioned families who don't have the money, to pay for the private school up front, which is many families. The tuition on these schools is daunting. So are there any recourses for families who do not have the resources to pay for these schools up front? And Sue, can you speak a little to either Connors funding, or what if some of these students might have qualified for financial aid in their private school? How does that work with outplacement? Is there any recourse available in terms of assisting parents who place their child privately at These are the independent private schools.
In the city, there certainly is
Right.
lower. I mean, in the city, there's
And
certainly
in the suburb,
honors
in
rules.
Westchester and Connecticut, what do you do for these families?
So, I mean, sometimes some of the private schools, I mean, to the extent they can, are actually really excellent at giving financial aid when they can. And
how does the financial aid piece, so if you qualify for financial aid, how does that piece play into the outplacement process? Or
So if a family unilaterally places into a private school and they're getting financial aid, one of the issues is they often don't find out about the financial aid until they've already signed the contract with the school. But in fact, that's usually the case. As far as though dealing with the district and seeking reimbursement, ultimately the district would become aware of what the family actually paid, because in order to receive reimbursement, you have to show proof of payment, and the proofs would add up to, would indicate what their financial aid was. So that does become part of, in essence, it becomes part of the settlement agreement. It also makes the case a lot easier to settle. If you have a program that costs $70,000 per year and the family ends up only having to pay $30,000 per year, getting a $20,000 settlement from the district becomes very feasible then, and becomes a much higher likelihood of the case resolving at that point.
What we're seeing in Connecticut.
I just want to make a point here about financial aid in terms of special education, private special education schools. It's really important to understand what the financial aid is. Is it actual financial aid that is being provided through the private school's endowment or a special fund that they have for financial aid, or is it a tuition discount? Because if it is a tuition discount, the school can run into a financial issue and withdraw the purported financial aid for the family. We have had an incident with that happen where the family had a settlement with the district and they had financial aid for the rest of it. The school ran into financial difficulties, withdrew the financial aid, and the family had to go back to the district to renegotiate the settlement with the district. Now that's a nightmare. So it is really important to understand if the financial aid is actually financial aid. There's a fund, there's a budget, and they're allocated to this many families in a particular year, as opposed to we're just going to discount your tuition by $20,000, because those are two very different things.
There's now a standard practice in Connecticut that on every settlement agreement, the district gets some benefit of the financial aid. And so if there's, a $60,000 placement, and there's, $20,000 in financial aid, it's often a negotiation. But what we usually work out in that case, if the district is paying $20,000, that they get 1/3, because of 1/3 of $60,000, 1/3 of the benefit of that financial aid. And that's an absolute requirement for districts in Connecticut now, that it's in the agreement, that there's full disclosure, and that they benefit from any money given by either financial aid or tuition reimbursements or any of those sorts of things. It's a shame that we've gotten to that place, but that is a critical part of the negotiation of any settlement agreement. And while I'm at it, I suppose, look, these settlement agreements for unilateral placements are highly complicated documents with a lot of ramifications. I would strongly suggest that anybody who's doing one of those, do them through a lawyer, use a lawyer. A lot of people do it with advocates. The big difference is, and we're not any smarter than advocates maybe, but if we screw up, you can sue us. That's called malpractice. If an advocate screws up, you have no recourse against them whatsoever. And so it's buying an insurance policy to go to a lawyer to at least review your settlement agreement and go through with you exactly what it means, and perhaps negotiate changes in it. It can be an enormous problem.
I want to ask a logistical question, but one that's very important for parents to understand, I think. When you do place your child privately, how does it work with transportation? who's responsible for getting your child there? Is this something that's easily obtained through the district? Who wants to take a stab at answering how transportation works?
Well, this is entirely different in New York and Connecticut.
Right. So do you want, let's start with, why don't we start with New York?
Okay.
And then we'll move to Connecticut. So Westchester, yeah.
So to begin with, any student does with or without an IEP going to a private school in New York, if you live within 15 miles of the private school and you apply by, they changed the rules just because of the pandemic this year, but in past years, it's always been April 1st. If you apply by April 1st and you're within the 15 miles, you get it. You don't have to think about the IEP or special education or any aspect of that and worry about it and have to fight over it. If you do it by April 1st and you're within 15 miles, then you get it. It becomes a very large issue because the schools that are very popular in Westchester are always like 15.3 miles away from the family's home. And that disqualifies you because the districts they have to cut it off somewhere, and they cut it off at that 15 miles. As far as from the IEP process goes, up beyond 15 miles, or if you didn't do it by April 1st, the basic concept is that a district is obligated to provide transportation if the private school, the unilateral placement, the let's just say the non-approved private school, is basically implementing the IEP or implementing the tenets of the IEP. I can tell you that different districts interpret that in different ways. And a lot of that also is different attorneys, board attorneys interpret it in different ways. So we know that certain board attorneys are very sort of understanding and sympathetic about that, and all of their districts will grant it in, as long as it's closed. And there's some others that don't, and that can become part of transportation, then can become part of the negotiation. It can become part of it can be actually its own hearing, but it can become part of the overall hearing as well. So it's something to be very cautious about. I would say that overall, it's an issue that our clients worry about over the summer, because the decisions often we don't find out about till August. Our clients worry about them over the summer. Most of the time it works out without it ending up being part of settlement, but once in a while it doesn't. And enough that we have to let our clients know that it's a possibility that the district will deny it.
Thank you. And in Connecticut?
In Connecticut, okay, if it's an IEP placement, the district has to provide transportation, period. It's that simple. If it's a unilateral parental placement, the district needs to provide transportation if the school is a nonprofit and if it's located within the district. Okay, so that's one rule. The next rule is that for other unilateral placements, districts are under no obligation to provide transportation, and it is part of negotiation. Generally, if there's transportation already available to that place, the district might be agreeable to putting it on, but they're not going to put on a bus for another kid. One thing that the parents really need to understand is how unbelievably, hideously expensive transportation is. Taking a kid, 40 miles every day to a private school could well be $40,000 or $50,000. There are many cases where the cost of transportation exceeds the cost of tuition. And that, of course, goes up astronomically if you need an aide on the bus or a nurse on the bus. And so transportation is rarely available for unilateral placements, is the bottom line.
A lot of times when it's a negotiated situation with a settlement agreement, then the school district provides an allowance for transportation. And again, this is negotiated, so it's different with every agreement. But I find that many times they're willing to, if they don't have a student already going to that placement, then they could provide at least an allowance and pay for the transportation. It's nowhere near what the transportation costs. Andy just pointed out, it's unbelievably expensive, but at least it's something.
Well, and the allowance is the IRS business transportation rate, which is for the moment 57.5, although it's going to go down very quickly, times the number of miles, and often it's 2 round trips a day. That's not always the case. But districts want to know if you're in a carpool. They and things like that. And if tuition's 60 and they're paying 40, they're not going to add transportation on top of that. I mean, it's just another piece of money out of their pocket. So it's sometimes we get mileage, but very frequently we don't. And from the point of view of the parents, it's sort of fungible. It's a wash.
And one final thing that I would say, which is not legal at all, about transportation, is that if you do have transportation, it's governed by the district that is providing the transportation. And that can be an issue sometimes if the schools have different breaks, or because if your private school has school and the public school doesn't have school, you're taking your child to school. They're not providing the busing for that. Same is true if your home district calls a snow day and your private school is still in session. Guess what? Your bus is not coming. So that's another sort of sticky thing.
And that's gotten astronomically worse with COVID.
Absolutely.
Where the private schools have tended to remain in person, and a lot of public schools have had to go all remote. And in that case, they're not providing transportation to under these sorts of,
because they're not in session.
Now, if it's an IEP placement and the private school is still in, I think that's pretty clear that they still have to provide transportation, although we've had that fight with districts all throughout the state over the last few months.
I have a question from the audience. What advice do you give families who have other children in the district they are suing?
I get that question all the time. And I actually, and my feeling on it is that I know there's a concern that, I have another child, that there's going to be retaliation, or there's going to be, my child's going to be singled out. I actually think that what tends to happen is that the family, and please, I hope this doesn't come across as me trying to tell people they should get a lawyer, but when the family has a law firm that's helping them with a special education matter, the district then knows they have a lawyer. They know they have somebody on speed dial that they can call. I've never heard of it. I've never had one family. I've had every family ask me that question, and I would ask the same question. I think it's a very, very reasonable one, and it's something that I understand why there would be concern about. But I actually think it goes the other way. I think the district can be a little bit on eggshells with that family, and they're actually very cautious in making sure that because they know they can pick up the phone and call. Something happens with another child in the family, that family's calling me. So I think that it actually doesn't result in retaliation or a problem for the other students at all. But I completely understand the concern, and it's something that it's asked all the time.
I totally agree with Paul. And usually what I say to clients is, retaliation, make my day.
Yeah.
Yeah.
Can I let me return to this money issue, which I think is I think this is the Achilles heel of the IDEA, that the statute does not work for people of limited income.
Yeah.
And that's and that is just a critical issue, and it's gotten worse since the Supreme Court said that even our experts cannot be, we don't get compensation for them, even if we win a hearing. And tuition's one thing, but Paul and I have been talking about neuropsychs, which can be $7,500 or more. That's real money, and it is just a scandal of the first order. It is an example, I would say, of the systemic racism that pervades American society. That we have a special ed system that benefits the wealthy and is in many ways not particularly available to people of moderate and lower income. It's a scandal.
Are there certain types of cases, though, that you feel, certain profiles for students where the school districts are outplacing? Like I know that some school districts, for a student, with such severe such severe autism or with such severe needs, maybe some medical diagnoses, it doesn't take that much cajoling or advocacy to convince the district. They simply don't have a program. So in those cases, I would imagine that income is not, those families are not at a disadvantage, right? But
Well, I mean, behavioral kids get outplaced.
Yeah.
And seriously medically fragile kids get outplaced.
Mhm.
And
So
and there are poor kids in inner cities who do have appropriate programs. But the right to challenge the district is
Right.
unavailable to people except if they have money.
and that's why we have SELF. So that was part of the inspiration, because we do see that there's just this inequality, and especially now with COVID, I think we can all agree that the gap is widening. And are there any trends that you've seen? Have you seen the outplacement process affected by COVID, or what's been the biggest kind of change you've seen? I know, Andy, you mentioned the fact that you can't do the observations. Are you seeing an increase in outplacing? Does anyone want to speak to that?
Well, Terry's been trying to talk for a while, so I'm going to defer to Terry, whatever she wants to say.
Well, I definitely, before I get to that question, because I think that's a great question, Laura, I want to talk about the 10-day written notice, because when we're on the topic of reimbursement, those families who want to unilaterally place and go after the district because they didn't provide an appropriate program and they want to reimbursement have to provide a 10-day written notice to the district. If they don't, before they remove their child, and if they don't, they run the risk of the hearing officer either reducing or denying the reimbursement. I think that's something that many families don't know about and need to. Now, this is all in the discretion of the hearing officer. It doesn't mean that the reimbursement, if there is reimbursement, will absolutely be denied or reduced, but it is a concern. And there are exceptions to this, but I just want to make sure that parents are aware of that. On the issue of COVID, I find that the biggest issue, at least in my caseload, is for those students who don't have the executive functioning skills to be able to be independent and to work when they need to diligently and complete their assignments without the supports when they're remote. So a lot of these schools right now are hybrid models. And so the students are home part of the time and then they're at school. So when they're in person, they do so much better. But again, I think the issue, I think, in terms of just a lack of progress and really implementing the IEP is when they are remote.
Yeah.
Well, this brings up a whole different issue, which is, according to the U.S. Department of Education, there is no waiver of IDA requirements, no diminution of FAPE requirements because of COVID. That message has not gotten to local school districts. And so there are a lot of parents who would like to place their kids privately because they're full-time in school. And the district program is hybrid or moving towards remote. So the kid's not going to be in school. And for the reasons Terry talked about, the child needs an in-person program. Demonstrating that the program offered by the district is inappropriate, in part because of COVID, is an interesting task. Now, that there are dozens of those cases sort of percolating through. Generally, the court decisions have said that a FAPE has to be provided, notwithstanding COVID, but that's not universal. I think that's a really dicey proposition. What we have in Connecticut is a system where the IEP has to be written as if the child's in school full time, and then we have something called a learning model IEP implementation plan, an LMIIP, which is how FAPE is going to be delivered in the remote or the hybrid setting. Districts have taken that to mean that they can provide FAPE Lite. But this is, let me stop there. We could do a whole program or a whole set of programs just on this issue. But it comes down to the point that we have to win on a unilateral placement. We need to show that the district's program was inappropriate, and big question mark about whether a program that's inappropriate because of COVID would get you that unilateral placement. Big question mark on that.
I've got a question. Thank you, Andy. I've got a question from an audience member for Paul. If a New York State school is approved for one disability category, can a child still be placed in that school if they have another disability category?
The simple answer to that is actually no. But the way around it that it comes up all the time is if the CSE in a suburban district or the CBST in the city, if they're willing to place in that school, got to get to the CSE and you get the classification category changed. Mm-hmm. But the answer is no. I mean, the New York, I'm not a big believer personally in classification categories. I think that they almost shouldn't exist. But the sort of the structure of that and the inflexibility of that does cause problems, because a school will have maybe even 3 categories that they can accept students, and the student will be in a 4th category, and but the student, that program is appropriate for that student. So we just have to work to get the category changed. I mean, most of the time the district, the CSE, has no issue doing that, but it can be a process. But yes, I mean, that's a very good question, and it does come up surprisingly often.
Mm-hmm. I actually have another question for all of you in terms of residential outplacement. Are you seeing, what trends are you seeing in residential outplacement? And are you seeing a greater willingness by school systems to fund a piece of the residential placement, like the education piece and not the residential piece?
I mean,
Anyone?
Fine, I'll jump in. You know, the basic belief of schools is that no child needs a residential placement for educational purposes. And that's always something we're overcoming. Now, they do place residentially for under IEPs on occasion, medically fragile, incredibly behavioral kids. We do work out cost sharing arrangements for residential placements that usually are what you say. There are three buckets. The school costs, you know, $120 a year. 30,000 is for room and board, and then that leaves 45,000 for clinical and 45,000 for educational. We're usually pretty good on getting educational, and the fight is over the clinical. And then there's this absolutely unjustified distinction that districts make between educational and therapeutic, that suggesting that they're not responsible because somehow it's medical, which is of course, inconsistent with what the Supreme Court has said. Medical is what it needs a doctor on site to implement. Anything less than that is not medical. But that's a position schools take. And so that's always an issue of negotiation. How much of that non-room and board piece the district's willing to pay for.
It is the most restricted placement as well. So it's harder than ever, I think, to get that. And you really have to show that you can't separate the educational needs from, and the school is not responsible for the medical piece of it. But if the child can't access his education and receive FAPE, then they do have to provide that residential placement. But they don't happen very often these days.
Let me bring up one more complexity, if I can, in Connecticut. Maybe I shouldn't even bring it up, but districts can get excess cost reimbursement from the state if the cost of the placement all in is more than 4.5 times the average per pupil cost. The amount of excess cost reimbursement is running at about 67% now of the balance. above the 4.5 times. They can only get excess cost reimbursement under an IEP placement to an approved school, or an IEP placement to an unapproved school for other than educational reasons. This issue of excess cost reimbursement is a major distortion on the whole negotiating process. But for placements that are in the six-figure range, it becomes a very important factor in negotiating a settlement and knowing the rules of excess cost reimbursement. But again, this is probably not something that should be tried at home.
I have a question. How long should you give a district to determine, this is obviously a very delicate, negotiation balancing act between, the parent and the school team and the district. I see a lot of families that are concerned with the length of time that it takes to, go through this process. And so the question really is, how long do you give a district to determine whether or not they're going to support an outplacement?
I mean, I would say on that, it's I think Terry said something like this before. It really depends upon the individual case. If the student is really struggling and it's having a very negative impact on the student, or even just a negative impact on the student, and family's in a position to unilaterally place, let's say, it may be something that you move on quicker than a case where it's not having quite the same impact. The other part of it is, remember that expert report piece is still key to this. You still need to get the expert report. You still need to have that in place. You have to have your case lined up before you move forward with it. There's not a hard and fast rule on the amount of time you need to spend there in the district. It's funny, Lara asked me at the beginning, what's one of the things that families are sort of most confused by or surprised by. I think that actually is one of them, is that when I'll say to them, listen, I hate to say this, and I as long as it doesn't have a negative impact on your child, like, you may need to try the program. You may need to try it for longer than you're really planning on it, because we have to see if it's going to work, and we have to get our expert report together, and we have to be building a case. We can't just assume that the district's program is going to be deemed inappropriate.
Speaking from a parent's perspective, and as someone who has been in that situation, it's very, very, very hard to send your child to school to fail every day. And I spent, many months dropping my son off at school and crying in the parking lot, every single day. So it's a very, very difficult thing to do that. Even though I know that, when you're building your case, you're building your case. And, if they're going to fail the child in the school, then, let them fail, and, and then you have more evidence on your, in your case. But it's very, very difficult to do that.
So the two things that I say more often, that I say in every single intake meeting with the family, anytime I'm giving a presentation, anything at all, is what is good for the two things are what is good for a case is not necessarily what's good in the immediate future for a child. And we're all child-centered people, and so it's very hard. Not that the burden's on us, but that it's hard to give that advice. I never want to say to a family, you need to put your child through this. I just explain that, look, this is how it could impact your case, but your child comes first, and it's just, that's a very hard decision. And the other thing is, and Terry and Andy said similar things before, but when you unilaterally place a child, in some ways you're letting it, depending on the timing of it, you're letting the district off the hook. You unilaterally place based upon your belief that the program's not going to work, and maybe the district's program wasn't going to work, but they may never have had to implement the program. So if you have a student who wasn't eligible for an IEP, the district proposes an IEP, and the family unilaterally places, well, that's a tough case, because we've never really seen that evidence built about whether or not the district's IEP would be appropriate. We let them off the hook. So, I mean, that's where your expert comes into play, but very tough case you've created now.
What I say to people all the time is the IDEA is a failure-based system. You've got to show failure before you get relief.
Right.
And, there are lots of cases where we know that the kid is going to, explode in the next year. And we'd like to do something now to prevent that. But the system does not allow for that. The kid has to fail first. And, sitting in the parking lot watching your kid fail is not a pleasant thing to do, but that is usually the only way to get relief.
And usually when families get to us, by the time they get to us, there is a decent amount of evidence already in the educational record. Parents know when things aren't working. They know when their child is not succeeding. So even though it's important that we need to have experts and we need to build our case, and it doesn't happen overnight, I think that there's already something in that file that we can work with, hopefully, to help the parents sooner rather than later.
Right. So I'm just thinking for the parent who might be listening, in tears, thinking my parent has to fail. Is it also fair to say that you have to be able to show that your child's not making meaningful progress? Is that enough? I mean, do you have to wait until your child is, having meltdowns and tantrums and crying every day? Or is it enough to say that, my child is not learning to read and he's in 4th grade? How long does the child always have to fail? I mean, or if you've done a good job of collecting data, that the child's not making meaningful progress. I guess, what advice can you give to those families, who don't want to get to the crying in the parking lot moment?
I think Lara, you just answered the question with what you said. It's collecting that data. You collect that data. Make sure that you have collected. You always, families that I always think that one of the things that the three of us could do and other attorneys could do is speak to families when their children are coming out of preschool and say to them, just start documenting.
Right. Keep every email, a paper trail.
Don't just talk to the teacher and you run into the teacher and and you have a conversation. Oh, your child's emails, data collection, get progress reports. Don't let the documents be, they were progress monitoring, but nobody knows where those documents are now. Constantly collect that data, constantly communicate, constantly express your concerns, because then when you come to us, right, then when the family comes to us and we see the stack of information, there may be enough there. There may be enough there that we can use, as Terry said, that we can use, and maybe we don't have to go, all right, now you have to try for 6 more months and it's going to be difficult and you're in the parking lot, and it breaks everybody's heart to hear that, right? It's what you want to be. If you come in and you say, when a family comes to us and we're like, okay, now we're going to start documenting, that's hard, right? You could be talking about a 5th grade student who's struggling to read and they're already in 5th grade. Have that, if the family, if they have the information, if they have the data, if they've collected it, there are usually things that we can work with there. They're usually.
And what
I would
about?
even suggest being more aggressive about that.
Yep.
Let's say you have a kid who's got reading issues and it's beginning of 3rd grade.
Right.
You go to the IEP team meeting and they tell you that they've got this great new program they're going to put in place. Well, you go to your local reading specialist and have them do a certain number of tests on the area of deficit on day 1, and then do it, 3 months later and 6 months later. And then you have the data showing a lack of progress, a failure of their program. Relying on their data is always hit or miss because they're smart enough to cook their data.
Right, especially in a lot of their data when it comes to reading can be very informal, and it can be, it's the Fontanella score is going up. Absolutely, I agree. Yeah, get a baseline and get periodic updates from a private professional and have that together. And absolutely, it's important to be aggressive.
And there is no area more than reading where the standardized tests given by schools are garbage.
They're terrible.
Terrible. They don't measure what they're supposed to measure. they don't tell you much about reading. And so having your own, which are actually using useful instruments rather than things like Fontes Pinnell or, you know, degrees of reading power or whatever, you know, is really important.
And even when you are, you know, there is data being collected in the classroom, it's always important to ask, you know, who's collecting the data, you know, particularly in a behavioral situation where if you're looking at behavioral data and you've got a classroom teacher who's got 25 kids and they're supposed to be like taking data on your child for, you know, 2-3 hours, however many, you know, periods a day. I mean, realistically, are they getting all of the incidents? Are they, you know, are they getting the antecedent? Are they getting, you know, are they getting everything? No, they're probably not. So that's also an important thing to, you know, to know when you're, you know, when you're looking at data and thinking about data is who's collecting it.
Particularly for
And
behavior.
keeping the district accountable. If they say they're going to do something, make sure they do it. Don't wait until the annual review to find out that they haven't been implementing or they haven't been doing something with, you know, reading instruction with fidelity, for example. So it's asking the questions, but doing it in a way that doesn't put the district on defense mode, right? No district likes to be told that they're not doing their job and they're failing. So it's really looking at the facts, looking at the data. The data doesn't lie, right? We can interpret it differently, sure, but if we point to the facts, then we ask them and try to hold them accountable. Why is the data, why are we seeing the trend go, why is it flat or why is it going down? Can you explain that? As opposed to saying, you're failing my child isn't getting a good education here. Think that yes, be aggressive, keep them accountable, but do it in a way where you're trying to at least maintain the relationship with this district. Because again, if they don't like you, they don't want to work with you, and ultimately that can help your child. So it's being assertive, holding them accountable, but doing it in a way where you really don't put them on the defense.
That's a great point, Terry, particularly about you know, keeping that collaborative relationship, you know, and the communication, you know, lines open as long as you can, because, you know, a lot of parents, I mean, you know, for many of us, you know, our children are in the system, you know, for, you know, 15 years or more, you know, and it's, you know, it can be, it's if you've blown that relationship up when your child's in second grade, it can make it hard, you know, harder, you know, when your child is in the transition program or whatever. You know, very few people can, you know, withdraw their child from the system and, you know, and just withdraw. So it is important to try to, you know, to be collaborative, you know, as much as possible, you know, as long as possible, as much as possible. I have one final question because I know that we're, you know, we're pushing up on 8:30, or actually we're over 8:30. What has been your experience in the trend of districts filing for due process in the last, you know, few months? Are you seeing it more often? Are you seeing it less often? What are you all seeing in that, you know, in that area? Let's start with Terry.
I think it's more common than ever for districts to file for due process if the parent asks for an independent educational evaluation, because at that point, the district has to do one of two things. They can say, yes, we will fund that. Or if the parent disagrees with one of the district's evaluations, or they can file for due process to prove that their evaluations were appropriate. So you're seeing more districts not agree to IEEs and file for due process. And part of it is sometimes it depends on the district, it depends on the special ed director, it depends on the board attorney many times. But many times it's an intimidation strategy, because if you as a parent assert your right to an IEE, if you disagree with one of the district's evaluations, then you get to choose your evaluator. So many times districts file for due process because they want the parent to use, they want to negotiate maybe their evaluator, because as we've been discussing, the evaluator is critical in terms of not only building your case, but being able to be successful and prevail at due process. So the evaluator is a critical piece, and I'm seeing that districts are filing more often than not based on that issue.
Andy?
Well, I mean, IEs are the big area where they file. There are cases of non-compliant parents where there is some filing as well. That's been relatively limited, and there are some severe limitations on what districts can do there.
Can you explain what you mean by non-compliant parents to the audience?
Oh, you know, I mean, the case we talked about before, where there's the school considers the kid a terror and wants to place him in a behavioral school,
Mhm.
one of the behavioral schools, you know, which used to be called reform schools,
Mhm.
and the parents not agreeing with that. That does happen on occasion. I don't think there's a big increase in that. But we have, you know, and this is not the people we represent, but in the you know, poorer communities and minority communities, we have a high level of distrust of the public schools, and a fair amount of resistance to what's being proposed. And there are some you know, public school administrators who would like to try to force the parents to you know, take an action. And so there's not a lot of those filings, but there are some. You know, IEs is obviously the
main.
the big contested issue, and you know, is it worth, you know, doing a $10,000 hearing to get an $8,000 evaluation paid for? The answer is no. I mean, if you win the hearing, you should get fees on it, but it's just
Yeah.
costs, and it's
And time.
the IE system is really terribly broken.
Paul?
So we almost never get a district filing on an IE even. It just doesn't seem to be something that they really challenge. Where we're seeing more filings is in that sort of that compliance issue. If families aren't consenting to evaluations, or if they're not agreeing to a placement, we're seeing more filings. But what we're actually seeing more of than that is that when the families file, something that's happening a lot more lately is we're getting motions from board attorneys in a variety of different cases, and they're bringing motions for summary decision or to dismiss, depending on where you are, that the family's case should be dismissed because they weren't being compliant with the process or something along those lines. So it's very similar to the district filing when you think about it. But that's what we're seeing a lot. That we've seen a big increase in that over the last 2 years.
And that's in Westchester and New Jersey primarily.
Westchester, New Jersey. Actually, it happens in Michigan a lot too. But yeah, I don't know nobody's from Michigan here, but but it's Westchester, well, Long Island, Rockland. I mean, really throughout New York, New Jersey. There's one firm in Michigan. They basically file a motion in every case. So, yeah. So we're seeing an increase of that almost everywhere. Even we do some work in other jurisdictions as well, and are getting motions. Like on a Colorado case that we have, they filed a motion for the same reason. And they're not really. I'm not gonna say they're not valid, but every single one of them is getting denied. They're getting denied every time because, and it's a way of running up the costs on the family.
Well, it's more than that. There's an obligation of the parents to cooperate, and the filing of a motion like that documents a lack of cooperation. And so, if you know, that is the third prong of the test for reimbursement for unilateral placement. And so, you know, it makes sense for their point of view to do that.
Wonderful. Well, thank you all again for joining us this evening. This was really a tremendous discussion. I apologize to all of the questions that weren't able to be answered, you know, in both the, you know, on both the platform and in my emails. But this presentation will be recorded was recorded if you missed any part of it. And we will be putting it up on Facebook within the next couple of days and on our Vimeo channel. But thank you everyone for joining us. Thank you to Lara for moderating this great discussion. Sorry, I was more active than I thought I was going to be. Thank you, Terry, Paul, and Andy for sharing your expertise, your experience, and your wisdom on this really, really, important and topic for parents. Thank you very much.
Thank you, everyone. Have a good night.
Good night.